This is what we're calling an intellectual property law and cannabis update. It's not intended as an introductory primer to the entire field of copyrights, patents, trademarks, and trade secrets as they apply to the cannabis industry. It's really intended as an update of a couple of new things that have happened in the last year, a couple of new interesting things. What they're handing out, the piece of paper, is my one piece of paper, 2 pages back, 2 sides, cheat sheet that is kind of my intellectual property law primer on 2 pieces of paper. The first page has a horizontal grid that compares copyrights, patents, trademarks, and trade secrets, which are the 4 basic intellectual property tools, on 5 different criteria, so you can kind of get a feel for what the differences are. And then if you flip that over, I created a fictional product that attempts to show how each of the tools can be brought to life in a real product. And the reason we're talking about this is, part of the reason is, this is the kind of work that I've been doing for 4 decades in general. Clothing, electronics, restaurants, music, TV, film, any kind of industry you can think of. I'm based in San Diego, California, but get up here all the time. And about 10 years ago, a light bulb went on that as this industry was starting to morph from an underground economy to a real enterprise for entrepreneurs and creative people and businesses to help get the medicine out, it dawned on me that it was only a matter of time before the investors were going to start coming in and saying, I like your product, I like your business, but how do I protect my investment? Where's the collateral? Where are the copyrights? Where are the patents? Where are the trademarks? Where are the trade secrets? And so about 10, 11 years ago, I just started learning everything I could about the industry and taking what I knew from intellectual property law in general and applying it to this industry. And so there's been quite a few developments in the last 10 or 11 years. You know, you hear a lot at this conference and all conferences about branding. You know, figure out what your brand is, protect your brand, figure out what your identity is, figure out what your personal brand is. But in my experience, particularly in the cannabis industry, branding without intellectual property, IP for short, protection, they go hand in glove. If you have IP protection but no brand, that doesn't do you much good. If you have a brand but no IP protection, that doesn't do you much good. You put the 2 together, now you got something that's going to be of interest down the road as you grow your business. Now, a lot's happened in the last year, a lot of new developments. Given the few minutes we have, I'm just going to touch on 3 or 4 of the ones that I think you'll find most interesting. Afterwards, I'll make myself available outside or downstairs at the lobby bar, depending, and I'll be happy to answer questions. But what's really different this year? What's changed in the last year? Let's talk about, for a moment, trademarks, brand names, logos, brand identifiers. Anything that identifies your brand from somebody else's brand. Exxon, Kodak, Xerox, Mrs. Fields, Apple, so forth and so on. Those are all trademarks. The Nike swoosh, it's a trademark. The Yahoo Yodel, that's a trademark. All these brand identifiers that separate your brand from the competitor's brand. This is a hot area. Before we talk about what's changed, let's talk about what hasn't changed. What hasn't changed, and it's still the big conundrum for the cannabis industry, is that the U.S. Patent and Trademark Office, PTO for short, will still not allow a U.S. trademark registration for anything that is cannabis, contains cannabis, or touches cannabis. So by touching cannabis, I mean retail stores, testing labs, and things like that, delivery services. So we have a real problem in this industry in getting federal trademark protection for the cannabis industry. That's a challenge. Right? That's what people like me like. We like challenges. So we spend a lot of time trying to figure out what the alternative strategies are. Now, what has changed in the last year is because on December 20th of 2018, the Farm Bill of 2018 was signed. Starting last year, 2019, the Federal Trademark Office started allowing trademark applications for hemp and CBD derived products or hemp derived CBD products with less than 0.3% THC. This is monumental breakthrough for the Trademark Office, because for the last 10 years, the Federal Trademark Office has had a total blanket wall against any kind of trademark applications, pardon me, for cannabis or CBD. So if you are or intend to be in the CBD business, you now have the opportunity to get some federal trademark protection. And just in December, 6 weeks ago, we finally started seeing the first trademark registrations actually being issued and granted for CBD products. That's new. That's news. We also think that, now let me back up. The challenge with CBD applications or applications for CBD products is the Trademark Office will no longer use the Controlled Substances Act as a basis for rejecting your federal trademark application, but it will cite the Food, Drug, and Cosmetic Act, which doesn't allow orally ingestible products to be marketed commercially, at least as far as the FDA is concerned. So the Patent and Trademark Office will reject a trademark application for orally ingested CBD products on the basis of the Food, Drug, and Cosmetic Act, not the Controlled Substances Act. We don't think that they're going to do that for sublinguals. We think they're going to draw a distinction between other orally ingested products and sublinguals. Why? I'm not exactly sure, other than the FDA considers sublinguals not to be nutritional supplements. So there's some opportunities there. What else can you do on the federal level if you can't get a trademark registration for your cannabis product or your cannabis service or your CBD product because it's orally ingested? Well, you'll excuse the phrase, plant some seeds by filing trademark applications for ancillary goods and services, clothing, educational services, website information, classes, videos. Those topics, those products and services, even though they concern cannabis, do not violate the Controlled Substances Act because they aren't cannabis, don't touch cannabis, don't contain cannabis. So you may not be able to get a trademark registration today for your cannabis product, but you can for ancillary goods and services. Good thing to do, build up some protection, plant some seeds for the future. What else? California. Well, one of the things that's changed in the last year is California, the 5th largest economy in the world, arguably therefore the most important cannabis economy in the world. California now is allowing trademark registrations for cannabis products and services if you are licensed to provide your product or your service by the state of California. That's a prerequisite. But you can get a trademark registration for your cannabis product or service in California, which you can't get federally. Given the fact that California is the 5th largest economy in the world, that's pretty good. By the way, most other states that allow for either medical or recreational cannabis also allow state trademark registrations. In the old days, most trademark lawyers were only concerned about federal trademarks. They didn't give two hoots about state trademarks. But in this economy and in this world where cannabis is hindered by federal illegality, state trademark registration's really important. Okay. By the way, state of California will allow you to file your trademark application online, something they didn't allow until last year. That's new. You can search for other trademark registrations that have already been issued online. That's something new in the last 12 months that you couldn't do a year ago. So you might as well, before you file your trademark application, spend your time, spend your money, see if anybody else has already gotten a trademark registration for the same or similar trademark so you don't run up against a brick wall. By the way, the state, what also is new is the state of California Trademark Unit is applying a much more strict scrutiny, looking much more closely at California trademark applications to make sure that the packaging and labeling is California compliant. If your packaging doesn't comply with California law, they will reject the trademark application and tell you to go back and fix it. That's new. The fact that the trademark office is looking at these trademark applications much more closely. What else is new? Last month, Kiva Health versus Kiva Brands. Show of hands, everybody familiar with Kiva Edibles? Kiva Edibles been around for quite some time. Well, there's another company called Kiva Health, a non-cannabis company. They sued Kiva Brands in federal court for trademark infringement, not state court, federal court, for trademark infringement, claiming that Kiva Health had a trademark registration, Kiva Brands was infringing. Kiva Brands, Kiva Edibles, filed a counterclaim, a cross-claim, saying, hey, not so fast, Kiva Health. We have unregistered common law trademark rights based on our long-standing use of Kiva for edibles in California. We may not have it registered for edibles, but we've got common law rights based on our long-standing sale of Kiva-branded products, which is, by the way, a valid legal doctrine. You don't have to have a trademark registration. It's really good to have one. You're not required by law to have one. You have these common law rights if you've been selling the product. Unfortunately, the court dismissed Kiva Brands' counterclaims against Kiva Health, said, sorry, cannabis is illegal under federal law. You're in federal court. We're not going to give your common law claims any credence in federal court. This is a game changer for brands and for trademark enforcement rights. I think it means a couple of things. Stay away from federal court if you can. Build up your ancillary trademark registrations on the federal level for those non-radioactive products and services, clothing, educational services, website information, so forth and so on, and get your state trademark registrations. There's a possibility that if you have more of your foundational bricks in place, you might be able to avoid a similar fate that happened to poor Kiva Brands. Also, you know, hindsight's 20/20, but I'm thinking now, if I have a client that's being threatened with trademark infringement lawsuit by somebody, I may not sit around for too long waiting to see what happens and going back and forth with the letter writing and the phone calls and can't we all be friends. What I might do is I might go racing into state court here in California and file a preemptive trademark action called a declaratory relief action in state court, where I think my client might get a better shake from the judge than in federal court, and say, Judge, we've been threatened, my client's been threatened with trademark infringement by this other company. I'm filing suit now because I want a declaration from you that we do have valid and enforceable common law trademark rights, and maybe state trademark registrations too. And I want to preempt this and get this into state court and keep it out of federal court. The federal court conundrum is also rearing its ugly little head in claims, litigation claims that are coming up now also in the patent and trade secret arena. Ironically, you can't get a federal trademark registration for cannabis products and services from the Patent and Trademark Office. You can't get a trademark registration if you walk in the patent door. I'm sorry, if you walk in the trademark door. But if you walk in the patent door, you can, because there's nothing in the federal patent law that says the patent office is not allowed to grant a patent for cannabis. There is a prohibition against granting a trademark. There's a specific prohibition by law against granting a trademark registration for cannabis, but not for patents. So cannabis patents are issuing by the dozens. Whether or not they'll be enforced in federal court, which is the only place you can go to sue for patent infringement, same with copyrights, you can only go to federal court, we don't know yet. These are the cases that are starting to rear their heads now, 2019, 2020, and in the future. In the good old days, when I first started doing this work 10 years ago, there were no lawsuits. Nobody was suing anybody. Everybody was holding hands, singing Kumbaya, we're all in this together. Then about 2014, 2015, when Colorado, Washington, and Oregon went legal, the stakes started rising, more money started floating in, and you started seeing non-cannabis companies suing cannabis companies over cannabis parodies, like Hashies instead of Hershey's, and Ganja Joy instead of Almond Joy, and so forth and so on. Starbucks filed some lawsuits. So you started seeing non-cannabis companies suing cannabis companies over these so-called parodies. And that was where most of the litigation was between 2014 and 2018. Then 2018, 2019 is when we started seeing cannabis companies suing cannabis companies. Hadn't seen any of that really before 2018, but it was sort of the inevitable consequence of the increase in the financial stakes that's taking place and all the money that's floating in and coming into the industry. This has happened for 100, 200 years in our society. As new industries come online and become more mature, the bigger players, the players who are more aggressive, realize after a period of time that they can use the litigation system to cripple their competitors. I don't like it. I'm not saying it's a good thing, but it's happening. It happens all the time. It happens not just in this industry, but it's starting to happen in this industry. And I think if I'm invited back next year, I'm predicting I'll probably have 10 or 12 different trademark, copyright, patent, trade secret infringement lawsuits where one cannabis company is suing another cannabis company to report to you. It's happening. Plan ahead. That's my recommendation for 2020. Let's see, what else is new in 2020? Copyrights. Because we can't get trademark registrations on the federal level for cannabis products, for the illegality problem, the Controlled Substances Act, copyright registrations for your logos, your graphic designs, like let's take the ICBC logo. It's got all this rich detail in it. It's got the bridge, it's got the tower, it's got the sails, it's got the blue, it's got the green. That's what I call a graphically rich logo. It's not just a horizontal line and a vertical line. It's got some real content to it. That graphically rich logo that you see up there, and which hopefully many of you have to identify and distinguish your brands, those can also be registered not just as trademarks, but with the Copyright Office. Not the letters ICBC, but all the graphics. Copyright protects content, graphics, illustrations, drawings, photographs, computer programs. So because we can't get trademark registrations for cannabis products, copyright registrations to be filed with the U.S. Copyright Office, copyright.gov, very simple, $55, the best bargain around. You can do it online yourself. I'll be happy to do it, or guys, people like me are happy to do it, but honestly, if you have the bandwidth, you have the patience, and want to open up an account, you can do it yourself. What's interesting about copyright registrations for graphically rich logos, the Copyright Office doesn't care that your business is a cannabis business. They don't have no prohibition against granting a copyright registration to a cannabis business. They're agnostic. You fill out the form right, you pay the fee, you provide the specimen, the evidence of what it is that you're using your copyright on, they're going to register that copyright for you. And if somebody infringes your copyright, you get to go to federal court, not state court. And we don't know how judges in federal court are going to view copyright infringement claims. I think they're going to be favorable, but I don't know that for a fact yet. But at least you have the copyright registration and you have something to hang your hat on. The other advantage of copyright registrations as a supplement to all your trademark registrations is, unlike the trademark office, which divides all goods and services into 45 different categories, and you have to pay a filing fee of either $225 per category or $275 per category. So if you want to file for clothing and educational services and website information, that's going to be 3 categories at $225 a pop. The Copyright Office essentially has one category, $55. So if you're putting your trademark on cannabis and clothing and somebody puts it on lunch boxes and bed sheets, you can make a claim against them for copyright infringement without having to pay $55 times 3, 4, 5 categories. I'm really bullish on copyright applications for the cannabis industry. What do you think? Are we done? Oh, 4 or 5 minutes.
You have a question? Do you mind taking a few questions?
I'll take a few questions.
All right.
We got time. You let me know when we're done, Ngaio.
So with the growing litigation over the trademark registrations, if someone is to go to federal court and lose, what type of liability do you think their attorneys are taking on, and what is the risk for malpractice, advising them on something we expect to go to court and be challenged and most likely not be upheld?
Well, it's a risk, obviously. Anytime you're out on the cutting edge, whether you're just giving advice or whether you're litigating, when you're the lawyer and you're out on the cutting edge, whatever industry you're in, whether it's cannabis or weapons of mass destruction or alcohol and other controlled substances, there's always a risk that the advice that you give a client is somehow going to backfire. We try to mitigate that risk. We try to use our brains. We try to talk to our colleagues. We try to talk to the other partners in our law firm and make sure we're not making obvious mistakes so as to mitigate that risk. But, you know, when you're out at the cutting edge, sometimes you got to push the envelope. I mean, that's part of our job. And whether or not something rises to the level of malpractice, boy, that's a tough one. That's for others who are smarter than I am to answer definitively. But, you know, it's part of the reason lawyers charge what they charge, honestly. I mean, lawyer hourly rates, if any of you have hired lawyers, you know they're pretty high. No pun intended. But
Higher than everyone in this room right now.
Yeah. But part of the reason is because we have to cover that risk and pay outrageous malpractice rates per year to cover those risks when we push the envelope. If we don't want to push the envelope, we shouldn't be in the cannabis industry. We should, we should represent yogurt companies and stuff like that. I'm not sure that answers your question, but I'm trying.
Are there any companies who have successfully defended their name as a copyright, or some of the other ways you're suggesting in the ancillary fashion against someone else?
So I didn't hear the beginning of the question, Ngaio. Could you repeat it?
Yeah, she said, are there companies who have successfully defended their copyright? Right? So you suggest getting a copyright instead of a trademark or something like that, and then you have a chance. So are there examples of people using that successfully in court to defend their property?
You know, right now, the amount of litigation that we're seeing in the cannabis industry, I can almost literally count on 2 hands. I mean, there's just very little litigation right now that's out there. I think there's going to be a lot more this year. I haven't seen any copyright infringement lawsuits. I've seen trademark infringement lawsuits, patent infringement lawsuits, trade secret infringement lawsuits, but not copyright. But I'm waiting, and I'm ready to go when, you know, if and when a client has the right set of facts. But I think it's coming. And as far as on the trademark side, well, if there's a plaintiff and a defendant and the lawsuit gets down the road, there's usually one winner and one loser. So there's usually one of each at the end of that fight.
Well, there you go. Thank you so much. Let's hear it again.
Thanks,
for Dave
everybody.
Branfman. That was very elucidating.